Are you about to go to mediation in a personal injury lawsuit? Check out this short video on the #1 way you can blow your mediation and some other tips as well. Hey everybody, Barry here with the LawFull channel. On this channel you're going to find short videos on the legal topics that affect your life. If you haven't already, would you please subscribe to our channel? And if you have any questions or comments, please reach out to me. If I can't help you, I'll try and find someone who can. Now let's jump into the video. So mediation can be used before a lawsuit is filed. However, the more typical scenario is that a lawsuit gets filed and then you go through some of the discovery process and then the parties engage in a mediation to try and resolve the dispute. A mediation can benefit you so much, but in this video, I want to start out by telling you the one thing you can do to blow the mediation wide open. And that is, you can go into the mediation and act, for lack of a better word, like a jerk. I had a mediation one time where the defendant actually showed up to the mediation. And the defendant was so interruptive during the mediation. He kept making faces and throwing his arms up in the air and interrupting people and commenting. Well, we weren't able to get the case settled at the mediation. However, shortly thereafter, the defense attorney reached out to us and we settled the case. And here's why. Because they realized that their client was going to be a horrible witness if the case went to trial. So it's critical to behave yourself with respect and appreciate what the mediation process is, an attempt to resolve your case, and also a place where you can learn information about what the other side's going to argue if the case goes to trial. So my strong suggestion is to act like an adult, to go to mediation with the good faith intent to try and resolve your case. But if that's not possible, and quite often it's not possible, it's a great place to gather intelligence about what the other side is going to argue and how you can counter their arguments later on. All right, having said that, I want to tell you a little bit about how the mediation process is going to work for you. So first of all, you were involved in a car or motorcycle accident, or maybe it was a dog bite case or a slip and fall or whatever type of personal injury case it was. You've probably filed a lawsuit and you've gone through some of the discovery process. You've answered interrogatories, which are questions that the other side can ask you and you can ask them. Maybe you've had your deposition taken. Maybe they've spoken to experts. And now it's the time for the parties to get together to see if you can resolve this litigation, to resolve this lawsuit amicably. First, you and the other side are going to pick the mediator you want to do the mediation. So you're going to have a say in who mediates this matter. Chances are it's going to be a judge or a very experienced personal injury attorney who offers mediation and maybe arbitration services on the side. The great thing about the mediator is that they are 100% neutral. They don't have a vested stake in the outcome of the mediation. They're not getting a percentage of the case. Their goal is to get the case settled if they possibly can. Now, if you're representing yourself, you may not know where to go to find a mediator. Don't just take the other side's word for it that the mediator that they want to use is a good person. Call your local bar association and get a recommendation. Oftentimes, there's a group of mediators who work in your area that you can select from. The mediator's job is going to be to listen to your side, to listen to the other side, and then to go back and forth with you to try and figure out a number that you can settle on that is satisfactory to both sides. The mediator will set the ground rules for the mediation in advance of the mediation, so you're going to know what to expect before you get there. Hopefully, you're going to meet with your attorney before the mediation and do some sort of preparation in advance of the mediation. And many attorneys, including myself, like to prepare what's called a mediation brief that updates the mediator on our position on the issues and how much we're looking to recover. Then the day of the mediation arrives, and here's how it's going to work. Generally speaking, you're all going to start in the same room. You and your attorney and the insurance adjuster and their defense attorney, with a mediator in the middle. Oftentimes, your attorney will start out and give an opening statement. You may even have an opportunity to say something if you want to. The defense attorney will then make a statement as well. And after that, what's going to happen is chances are you're going to split up. And the mediator is then going to meet with you and the mediator is going to meet with the other side as well. Sometimes people call that a caucus. They're caucusing together. And the idea is for the mediator to elicit information from you so that he can try to find a common ground between the parties to resolve the case. Okay, when it's your turn to meet with the mediator, to caucus with the mediator, with your attorney as well, listen to what they have to say. These people are experts. You may think you have $1 million case, but if the mediator tells you that he or she thinks that at trial you could recover $60,000 to $70,000, for example, you might want to consider listening to what the mediator has to say. Now, I'm not saying it's the end-all be-all, and there's no obligation in a mediation to accept any kind of settlement offer. I'm just saying it's a good practice to listen to what the mediator has to say about the strengths and weaknesses of your case. So the mediator is going to go back and forth between the rooms, between your room and the room with the defendant's attorney and the defendant's insurance adjuster. And hopefully, you're going to come back and forth and find a number that you can settle on. But if you don't, it's no sweat. Mediations oftentimes are unsuccessful, but that's okay. You used it. You showed that you would be a good witness on the stand. You used it to find information about the other side and what they're going to argue. It is not a waste of time, no matter what the result of the mediation is. Then what will happen after the mediation is over? The litigation will just carry on, and you'll continue to interview or do depositions or do discovery or whatever it is until you get your trial date. Now it's time for your take on the law. Were you involved in a personal injury lawsuit and you took the case to mediation? Did you settle the case in mediation? Tell us about it in the comments section below. Thanks for checking out this short video on an important legal topic. If you have any questions or comments, please reach out to me. And if you haven't already, would you please subscribe to our channel? Thank you, and we'll see you at the next video.